Good morning from the University of Florida. We're here at the Levin College of Law for the 5th annual University of Florida Law eDiscovery Conference. And it is my privilege and pleasure to be here with an institution of eDiscovery. I'm here with Tom O'Connor, Senior ESI Consultant at Advanced Discovery. Tom, as I said, is a legend in our business, our profession, our industry. He's the author of eDiscovery for Small Cases, the ABA book published a few years ago, and he's been involved in some of the biggest cases that we've had in eDiscovery, also some small ones. And Tom, I wanted to ask you about the eDiscovery for the solo practitioner, for the smaller firm. You've written a book on it, you've talked about it extensively. What's your best advice for small firms in eDiscovery?
Well, I think the first thing is don't assume that it is only a big case, federal case venue, that there are eDiscovery options available across the board for different case types and case sizes. And we kind of get wrapped up in our business about talking about, the multi-terabyte, multi-jurisdiction, complex cases. The National Center for State Courts, I believe, for the last 3 years has noted that at the state court level, the most common case type for eDiscovery requests is actually domestic. Hardly what you think about when you're talking about complex litigation with large amounts of data. So, and that seems natural, of course, because eDiscovery is everywhere. We've all got our smartphones with our entire lives on them. We're all texting, the rise of social media. So first start with the assumption that there is a solution out there, and then start to explore. The second part of that is that those solutions are expanding all the time. You mentioned the book, and thank you for doing that, because I get, I think, 10 cents every time they sell a copy.
Pleased to contribute, Tom.
Yeah. And I've actually been thinking about updating it because it's several years old now. And I waited actually deliberately because of one of the newer developments in this arena, which is the rise of Office 365 and some of their solutions built in to the operating system that can be used for eDiscovery, right in the sweet spot for small firms, solo practitioners. So,
Tom, we've been hearing for years on that same subject that email's dead, email's going by the wayside.
Who says that?
We hear it all the time.
I'm looking at Ralph Losey standing here, I'm thinking, well, we don't think email is dead, right?
And I think that Tom has just answered our question here. I take it email volumes are still increasing and it's not going away anytime soon.
Oh, yes. I mean, I think there are clearly in the social media realm, we've seen alternatives. The messaging system that's built into Facebook, for example, especially outside of the United States, is a very big method of communications. But yeah, I would hazard to guess that 75% of the data we get, certainly at our shop at Advanced Discovery, when we have to process data, is email. That's the bulk of what we get to process and then dump into Relativity. It's the business means of communication. I read the other day that something like 98 or 99% of all attorneys use email for business communications, which kind of begs the question, what are the other 2% doing?
Sure, yeah. You mentioned one thing that I picked up on there. You mentioned Facebook.
Sure.
I take it that social media has been a big change, and they used to talk about asymmetrical litigation, where one side had all the data, usually the corporate defendant, and the plaintiffs didn't have much of anything. I take it social media is changing that ballgame a little bit?
Oh, absolutely, because everybody uses it, and I think it'll cut back a little bit in the next year or 18 months because people are starting to realize, oh my goodness, that's evidence. People didn't think about social media as evidence, but it is. If you're talking about your case, if you're playing volleyball on the beach at the same time you're supposed to be at home nursing that bad back that you sued somebody over, yeah, that's all relevant evidence.
So social media sort of replaced the private eye in the tree at 2 o'clock in the morning.
Well, I wouldn't acknowledge that we ever actually use private eyes in trees at 2 in the morning.
Of course not,
but,
never happened.
I can't talk about specific practices. I don't know about that. Actually, all seriousness aside, as Steve Allen used to say, I think there's still a vast amount of investigation that's done by operatives or investigative agencies. It's just that people put so much out on social media without even thinking about it. And they'll say things that they wouldn't say. You, of course, went to law school undergraduate in New Orleans, right? You went to
Exactly,
Tulane?
yeah.
Yes, and I, of course, live in New Orleans, and the great New Orleans legend, the Louisiana legend, the Kingfish, Huey Long.
Absolutely.
In a very prescient moment once said, never put in writing what you can say on the telephone.
Good advice.
But people don't think about the internet as writing. They just kind of put things out there, and again, it becomes relevant evidence. And so I don't know that it's replaced the private investigator because it is so public. It's so easy to get at, and it's
Right.
so widespread that again, at our shop at Advanced, one of our forensics guys told me we've, in the last year, seen a 600% increase in requests for social media collections. So it's
No surprise
exploded.
there.
Yeah.
Absolutely.
Yeah.
You know, you mentioned New Orleans, and obviously a longtime New Orleanian and scene of a horrible tragedy in 2005. And I'm wondering if you could talk to our audience.
Talking about Ray Nagin being elected mayor? No. I'm sorry.
Let the record show that we are politically neutral here at the University of Florida eDiscovery Conference. Having said that, that's obviously a key. It's really
He was
hard
actually
to
elected
separate.
in 2003. So.
Well, but he was there in 2005. Disaster recovery is something that Katrina taught us well. As you know, that I covered the World Trade Center attacks in New York in 2001.
Right.
When you get into those type of situations, what role does e-discovery play? And you've got that experience. How did you do it, and what's your advice for disaster recovery in the future from an e-discovery perspective?
Well, the problem, of course, during Katrina was that we were a bit behind the times, not just in New Orleans, but I don't want to paint them with that brush, but really across the South in general. Or at least the Gulf Coast in general. And so data was being stored locally. In many cases, it was still being stored in paper. Deeds, mortgages, all the local county records were all paper.
Sure.
So the first lesson learned was digitize it. The second lesson learned was put it someplace other than in a facility that would then become inaccessible during a big calamity, whether it's a bombing or a storm that wipes out the entire city. There were law firms in New Orleans who were literally sending strike teams in, military like SEAL type guys, to walk up 20 stories to pull their servers and get them out of their buildings and bring them someplace. So the cloud has certainly surpassed all of that. Everybody, at least in our neck of the woods now, is very well aware. Multiple locations, use the cloud, ease of transfer, and not just for e-discovery, but really for everything. But it makes e-discovery that much easier. And in many cases, it isn't necessarily replacing the local operating systems, but it's either redundancy or in some cases a colo or another location I know one big firm in New Orleans, for example, and their colo is in Dallas. So if something hits in the Gulf, it doesn't matter, Baton Rouge to Pensacola, their data is sufficiently out of the way that they have protection. And then getting at it, I'm sorry to answer your question about e-discovery, to get at it, it makes it easier because we know where it is.
You know, tying these two topics together, e-discovery for small firms and solos and disaster recovery, it's often been said that you get as much disaster recovery as you're willing to pay for. Like, we can recover that data pretty quickly if you pay X. We can get it to you in 6 months if you pay a little bit less. What's your advice in a disaster recovery situation for the solo and small firms?
Well, I think it is relatively easy now. If you buy a new computer these days, whether it's a Dell or an HP or an Apple, you're going to get a solicitation from the company to give you storage on their server systems as part of the purchase. Well, you know, first 6 months free, after that, relatively cheap. Sure. I think I pay for a terabyte of data $15 a month, $12 a month. So first of all, look immediately at the option when you're buying a new computer. Is there something available to you then? And then even if it's not, you know, Microsoft offers backup in the cloud, Apple offers backup in the cloud, other vendors will offer backup in the cloud. It's not expensive, it's easy to do.
Do it, as they say in the advertisements.
As they say in Portland, just do it.
Absolutely. All right, you know, on a lighter note, we've got a theme going on here, and here's a question for you, a little bit off topic, and that is, if you could have one e-discovery superpower, what would it be?
I would like the ability, especially for attorneys, to cloud their minds and make them all cooperate. Right? Would have some sort of Vulcan mind meld that would allow me to impose the Sedona Cooperation Proclamation on all the attorneys in the known world.
We have the Tom O'Connor perspective on cooperation under the Sedona Cooperation Proclamation and the new take on the 2015 amendments to the Federal Rules of Civil Procedure on cooperation. Tom, thank you so much for being here.
My pleasure. Always great talking to you. Great seeing you.
Great to see you as well. I'm David Horrigan, eDiscovery Counsel and Legal Content Director at K-Cura Relativity. Been here with Tom O'Connor, Senior ESI Consultant at Advanced Discovery. Thanks for joining us.